Madam Clerk, would you open the courtroom for us, please?
The State of Michigan 36th District Court is now in session with the Honorable David S. Robinson Jr. presiding. Good morning, Your Honor. Good morning, everyone.
Good morning. Good morning.
Good morning, sir.
We are on the record. This is case 22-195-329. Credit acceptance versus Ronald Johnson. Appearances.
I believe it's Capital One, Your Honor.
Yes, and
I'm
it's a
sorry,
different
Capital
case.
One Bank. Yes, my bad.
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff Capital One Bank.
And what is your name, sir?
Ronald Johnson.
All right, gentlemen, where are we on this file? We have a request for motion for non-compliance.
Yes, Your Honor, this is a third hearing on this issue. It's our motion to reinstate case and for entry of default judgment pursuant to conditional dismissal. The first hearing was on December 16th. The defendant promised to catch up on back payments and pay $400. He didn't do it. The hearing was adjourned to January 18th. And again, he said he would catch up. He was going to pay $500. He said he paid $500 the morning of January 18th. And Judge Giles told him he would adjourn it 30 days, but this is the last time. And if he didn't pay it, the judge warned him that he's not going to adjourn it again. And as it turned out, the $500 check that Mr. Johnson paid on January 18th was an NSF check that bounced on January 24th. And then he paid another NSF check that bounced for $100 on February 15th. So we've had enough of the NSF checks, and we ask that the case be reinstated and that judgment enter against the defendant, which we submitted to the court previously.
Mr. Johnson,
Yes, Your Honor.
what do you want to say about this?
Sir, all I have to say is the $500 has been paid. It got paid when Judge Giles turned it over. I called directly and spoke with Ed McCracken, and he had there was one digit off in the account number. The $500 has been paid. I am currently up to date with the arrangements with Capital One, Your Honor.
What about the $100 that was NSF?
The $100 I'm not aware of as of right now. But I know the 500, Your Honor, was the amount that they said that I owed that needed to be caught up. And I paid that, and the only reason that NSF was because of a wrong number. And then I paid that. They took the $500 directly out of my checking account.
Mr. Beers?
Yeah, there's still one NSF check of $100 that is still bounced, and that was on February 15th.
Mr. Beers, your motion is granted. Submit your paperwork.
I will.
Thank you, gentlemen. Mr. Johnson, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in Wayne County Circuit Court. Thank you, gentlemen, for coming in. We're off the record.
Thank you, sir.
I think there is a proposed judgment in the file, Your Honor.
Send another one in. I can't seem to find it.
Okay, I will. Thank you.
Mr. Munson.
Good morning.
Seem to have Mr. Cox here. See if he's coming in here. There he is.
Sorry, Judge.
All right,
Sorry,
gentlemen. This is 22-191-505 Debt Holdings LLC versus Kelsey Baldwin. Date and time, adjourn date for a motion for summary disposition filed on behalf of the plaintiff here. Could I have your appearances?
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of the plaintiff.
Good morning. Grant Munson, P71994 for defendant.
Your motion, Mr. Cox.
Your Honor, very simple and straightforward motion, very simple and straightforward response. This arises out of a commercial lease agreement between the parties where the defendant was obligated to pay rent of $1,625 per month. There was a provision in the lease that expressly required the defendant to provide not less than 2 full calendar months of notice before vacating. She failed to do that. And because of that failure, she's responsible to pay those 2 months. The defendant's response to the motion for summary disposition doesn't appear to dispute this and instead relies upon an ordinance in Hamtramck that alleges that it's unlawful to rent a rental property as a dwelling in that city without a certificate of compliance. I think it's apples and oranges. The lease on its face clearly says that it's a commercial lease. It's not a dwelling. The ordinances attached by the defendant does not apply to our particular issue. And Judge, even if they did, I mean, I don't think that the ordinance says anything other than the landlord in that particular circumstance might have some issue with the city. I don't think that ordinance expressly says that it relieves the defendant of an obligation to pay pursuant to a written contract between those parties. And for all those reasons, Judge, we'd ask the court to enter summary disposition accordingly.
Mr. Munson.
Your Honor, I too agree that it's straightforward, but I disagree with the conclusion. There are 2 genuine issues of material fact outstanding in this case, and it really precludes summary disposition at this time. The first is who breached the contract. It's just false that this was a commercial lease. It was a residential property.
Excuse me.
Yes.
This is, am I confused here? I can concede myself frequently to be, but the lease describes itself as for a booking office and not as a private dwelling. Isn't that the lease that we're talking about?
It is, and that lease is flawed on its face. I mean,
Okay, so your argument is that the lease itself has some kind of flaws in it.
Certainly.
Okay,
Yes.
please continue.
I mean, this was rented explicitly as a residential residence. There was no business conducted in the location. Both parties were aware of that at the time that the relationship began.
Your client signed a lease saying that I'm going to do an event booking business when in fact your client was doing it as a residential district.
Apparently, yeah. I mean, my client.
Now, let me ask you this. Assuming that to be true, how then do you make a clean hands argument, sir?
Well, what I would say is that my client was a non-attorney layperson.
How do you make a clean hands argument when your hands are not clean? Even assuming, just for purposes of discussion, and that's all it is, because as you know, the district court does not have equitable jurisdiction except in summary proceedings, and this is not a summary proceeding. But even assuming I had equitable jurisdiction, how could you claim equitable relief when you have dirty hands?
First, I don't necessarily believe my client has dirty hands. Second, I think it's irrelevant because my client didn't breach the lease.
Okay,
so
let's say you don't agree that your client has dirty hands. What would you describe? And again, I'm really looking at your request for equitable relief, which again, I want to make clear, I do not have subject matter jurisdiction for it. I just don't understand how you would sign a lease saying it's going to be an event booking business. According to you, both parties know at the time, including your client, that it's going to be a residential lease. Again, please continue, sir.
Okay. and I agree. I don't want to harp on the equitable issue. I mean, that's not really the issue.
I'm looking
that
at
I
your
raised
brief,
in my-
counsel, not mine.
Right. And so in my brief, I don't really necessarily raise an equitable issue. What I'm saying is my client was planning on remaining at the residence. The lease terminated at the end of November of 2021. And on November 17th of 2021, the plaintiff tells her that the rent is going to be increasing $275 a month for the next term.
If she stays over,
Right. And so my client said, okay, I will not stay over.
okay,
I'm terminating, I'm moving out,
okay,
which she did. The lawsuit here is suing her for the 60 days after she moved out at the increased rent rate, saying that because she terminated the lease without giving 60 days notice, she's obligated. But the plaintiff had to give 30 days notice of a rent increase. And as soon as she got that notice, she said, you know what? I can't afford it. I'm out at the end of the lease. This lawsuit is not for rent during the term my client was occupying the premises. This is only for rent after she moved out. So
I got that.
that's one of my two issues. And then the second issue, which I don't really think is an equitable issue, is just saying that this was rented as a residential property, and that's fine. But the problem is that in order to rent a location in the city of Hamtramck, and I cited the ordinance, you have to get a certificate from
Yes.
the city saying you could do that. And there was no certificate. There never
Okay,
was.
I have a question about that.
Yeah.
And just so I'm reading from your brief. Beyond these issues is a public policy argument that a landlord should not be permitted to unilaterally and dramatically increase rent and then require the tenant to occupy the unit for 60 days at their rent without recourse. That's an equitable argument, Mr. Counsel.
It
I
is.
adjourn this thing to read your brief. So let's not pretend I didn't read what we adjourned for you, so I could read your brief, sir. Now, in regard to the city of Hamtramck ordinance, and incidentally, Mr. Cox, I don't understand why your brief says that the property is located at 18931 West 7 Mile Road in Detroit. I thought the property was in Hamtramck. Am I confused?
It is. No, Your Honor, that's a typo on the drafter.
No, that's a typo on you. This is sloppy lawyering, gentlemen. This is sloppy lawyering. In any event, Mr. Munson, the Hamtramck ordinance, apparently not the city of Detroit ordinance, and they're different because in the city of Detroit ordinance, the ordinance provides that a landlord may not collect rent without that certificate. But what the Hamtramck ordinance does, in my judgment, my reading, is very different. It says you may be liable for a misdemeanor. It says you may be liable for civil liability, but both of those are problems between the landlord and the city. It does not, the Hamtramck ordinance, unlike the city of Detroit ordinance, provide that a lack of a certificate is going to be a bar for the landlord collecting rent. Did I read that incorrectly?
No, I believe that that's what the ordinance says.
Okay. So then what we have is a situation where a tenant holds on after the term of the lease. Ordinarily, when you stay in a property after the term of the lease expires, and this is without regard to whether the lease is a commercial lease or a residential lease, you're deemed to be a tenant on a month-to-month basis if you were paying rent on a month-to-month basis, and the previous terms of the lease are deemed continued. However, the term here in paragraph 5, the lease says tenant shall be a tenant from month to month if tenant continues in possession after the end of this lease. As a month-to-month tenant, tenant's rent shall be in the amount set by management and tenant subject to all other provisions of this lease. So the lease appears on its face to modify the ordinary rule of holdover tenancy as a month-to-month extension of the then existing lease by saying the new lease, the new rent is going to be what the landlord says it is. Did I read that incorrectly?
That's correct. I want to be clear. My client did not hold over. My client did vacate.
Was your client
end
out
of-
of the property by the end of the lease term? 21st of November.
Well, that's something that was incorrect in the plaintiff's brief. The end of the lease term was the 30th of November. And my client vacated, I believe my client vacated on December 5th.
Okay, and help me out if I'm wrong, because I'm wrong a lot. But my understanding is that December is the month
Right.
after November. Which
I
means
apologize.
that, according to what you say, your client did not vacate by the end of the first lease.
That's accurate. My client vacated December 4th.
The client vacated after the first lease.
Yes.
So then, would she not be required to have the 60 days that the lease provides in paragraph 9? Tenant shall give management no less than 2 full calendar months written notice of tenant's intention to move at the end of the lease term or any time thereafter, which day of termination shall always be the last day of the month in which tenant is to vacate the premises. Wouldn't that be applicable?
I don't believe so,
Tell
because
me
my client gave notice on the day she was informed that the lease was increasing, that the dollar amount was increasing.
But she stayed in the property, according to you.
You're right. She stayed in the property another week.
She stayed in the property past the expiration of the last day of November 2021.
But at that point, if she's being charged as a holdover tenant, then the term becomes 30 days, not 60 days, because it's for the term of occupancy and it's a month-to-month tenancy at that point. So she couldn't be charged then for January. So even if that argument's accurate, then we're really only talking about December.
Mr.
But she's
Cox.
being sued for January, December and January.
December and January. Mr. Cox.
Yeah, I mean, the difference, Judge, is kind of, as you've already pointed out, parties are free to contract away common law legal rights. So, I mean, generally speaking, and absent any other provision, Mr. Munson would be correct. The tenancy would convert to a month-to-month tenancy under MCL 554.131, and he would be right. But we have a contract that says different. And the contract says that in the event that this holdover occurs as it did, and as it appears to have now been acknowledged on the record, that there is a 60-day notice requirement in order to terminate that tenancy notwithstanding. And because of that, she's on the hook for both months of rent.
All right. Thank you, gentlemen. I appreciate the briefing. I am going to grant the motion for summary disposition filed on behalf of the plaintiff in this. The common law was modified by the terms of the lease by saying that instead of just carrying over on the previous terms, the new rent is, and the parties are free to sign whatever they sign, whatever management says it is. And then it requires them a 60-day notice. Mr. Cox, your motion for summary disposition is granted for the 2 months of rent. Mr. Munson, you of course have an absolute right to appeal my decision. I look forward, Mr. Cox, to your order. Thank you, gentlemen.
Thank you,
Your
Your
Honor,
Honor. Have a great day, Judge.
May I just
Mr.
briefly
Munson.
clarify for the record? I understand the decision is what it is. I just want to be clear that the term in the contract does not say that. It says month to month. It does not say 60 days for a holdover.
Okay. Thank you, sir.
Thank you.
Thank you, Your Honor.
I was. Speak to you.
Hello, good morning.
Good morning.
Hi, I was here for the case, Your Honor, Diego Sanchez versus Golden Key.
Okay,
Okay,
don't
just
have
wanted to
your
make sure.
opponent, don't have your opponent as of yet. I wanted to let you know I knew you were here. Put you back in the waiting room. Now, where'd this other guy go? Hello? Hello? Hello?
Talk. Judge.
There we go. There we go.
There we go, there we go. Never fix it, never mind. Okay.
All right, you're on now, ma'am. What is your name?
Veronica Rome.
Okay, Ms. Rome, I don't have your opponent as of yet. He was here, then I think he checked out to another courtroom. So what I'm gonna do is I'm gonna put you back in the waiting room. But I want
Okay.
you to know that I knew you were here, okay?
Okay, thank you,
With you
Judge.
shortly. Yes, ma'am.
Okay,
Put you back in the waiting room. Should be a
Okay.
couple more minutes. Where did the other guy go? Hello? 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 If I don't hear from you, I'm going to remove you. And I know you can hear me because I saw the bar flash. All right, you'll be removed. Hello? Hello? Move this guy. Hello? Hello? Joshua Castmore. Respond or I will disconnect you. Hello?
Your Honor, can you hear me?
I can hear you. I'm tired of playing games with you.
I apologize, Your Honor. I don't know what's going on. It will not let me start video for some reason.
What are you here for?
I am here on Sanchez versus Golden Key Real Estate. I'm here for Golden Key Real Estate.
All right, hold on.
Okay.
All right, we are on the record. This is file 22-243-705. Diego Sanchez versus Golden Key Real Estate LLC. This appears to be our initial pretrial. By way of background, this case was initially filed in the small claims division and was removed to general civil. Your appearances.
Morning, Your Honor. Joshua Castmore, P76326 on behalf of the defendant.
Again, your P number, sir.
P76326.
Got it. And what is your name, sir?
Good morning, Your Honor. Diego Sanchez, the plaintiff representing themselves.
Mr. Sanchez, I want to tell you two things. First of all, you have an absolute constitutional right to represent yourself. Secondly, this is not small claims. In the small claims division, which is where you started your lawsuit, things are very different. The rules of evidence other than privilege do not apply. The court is not required to follow the case law, but it's to do, quote, substantial justice. We are no longer in that division of the court. We are now in the general civil division, and the rules are very different, and the rules are very formal. In the general civil division, which is where we are now, all parties, the court, litigants on both sides, must follow the rules of evidence, the Michigan court rules, as well as the Michigan statutory law and case law. If you decide to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Castmore will be binding on you. Further, if you elect to represent yourself, as is your constitutional right, you will not be heard to say you don't know the rules. In essence, if you elect to be your own lawyer, as is your constitutional right, you will be treated as your own lawyer. You understand these things?
Yes, sir, Your Honor.
Okay, so where are we on this file, gentlemen? What is this case about, Mr. Sanchez?
Your Honor, my argument is that, well, it's not really reflective on any of the documents I would have submitted this far. I would have moved for a request to amend pleadings, but I'm going to be honest with you. I'm a little out of my depth. Basically, what we've got going on here is I was a tenant of a building, 3737 Scoville, unit 10 upstairs. And as a tenant of that building, I was supposed to pay $650 a month for rent. Totally fine. I liked the apartment. I liked it, past tense. I had some issues that first winter. The electric bills were really high. It's just me. It's like a 600 square foot apartment. It's just me. And the heating bills were coming up to like $300 or so. Mind you, I mean, as far as discovery and whatnot, like, I don't know if we could get DTE involved in this, but I would like to think that I was not using an unreasonable amount of heating just to maintain me being alive. And I immediately alerted Golden Key. I let them know, hey, my bills are really high. We should probably look into this. And in terms of evidence, I supplied as many as I could in terms of the exhibits that were attached in small claims. So as far as submitting any evidence, I'd love to conform to the rules of the court. But I do have documentation of my correspondence with the defendant. I made numerous efforts. I mean, it seems almost countless. To let them know about this issue that was going on. Finally, like right before I moved, they looked into it. And that was coincidentally right around the time that I got the unit checked out, because I had already spent thousands of dollars in electricity there. for one person to spend almost $500 in 1 month on a small 1-bedroom apartment, that's kind of a lot. And I had people come in and take a look at it. I have videos of my encounters with the contractors who came in, and they said clear as day, it's this window thing. So I let them know a lot about it. I believe that I had demanded in small claims about 4,600 or so. That was the sum total of the amount that I owed from DTE. Mind you, I believe that the entire amount that I owe is somewhat up to, we cannot determine how much of that necessarily is my responsibility. I don't mind paying my own electricity bill, but like a reasonable one. And clearly several of these months, it was far higher than that. And that also hit my expenses with the credit card expenses and money that I have to make up for other things. And I was late on my payments for other things. Currently, I mean, my debt just from this entire situation is sitting at well over, several thousands of dollars. I just want something that's fair for this situation. I told them about it, and I'm just looking for just compensation. I spoke to Mr. Castmore, and we discussed. I told him that I thought that 2,500 would be fair, and well, Mr. Castmore can represent himself and tell you about our conversations. But that's
Okay, I don't
basically
want
where
to
I'm.
hear about settlement discussions.
I'm sorry, sir.
I can't hear about settlement discussions.
Oh, I'm sorry. Okay, my mistake. I'm sorry.
Let me hear from Mr. Castamone.
Your Honor, I think that we intend to file a motion for summary disposition here. Believe that the issues in this case are contractual. Mr. Sanchez renewed his lease one time. The issues with the window were repaired. Mr. Sanchez received a rental credit. The property has certificate of compliance and rental certification. So we're gonna be filing a motion for summary disposition here.
All right, this is what I'm going to do. I opened your written discovery January 25th. Have either of you started with written discovery?
No, Your Honor.
All right, I'm going to continue your written discovery. I'll give you another day, March the 20th at 10 o'clock. It'll be on Zoom like today. We'll continue your written discovery, and gentlemen, let's get at it. If you intend to do Mr. Sanchez any written discovery, you should get started on that right away. Likewise with you, Mr. Castmore, let's get started.
Sounds good. Thank you, Your Honor.
Thank you, gentlemen.
Thank you, Your Honor.
Castmore, let's get the problem resolved.
Yes.
March 20th, 10 o'clock. Thank you for
Thank
coming.
you, Judge.
Well,
Thank you, sir. Thanks.
be
Bye.
safe out there. Good morning.
Good morning.
Ms. Francis, why are you here today?
Judge, I have an 11 o'clock for 135.
Okay, that's 11 o'clock.
Yes, I'm just early,
Okay,
so I wouldn't forget to log on.
no problem. I'll put you back in the waiting room.
Thank you.
Ms. Rome, hang on.
Yes,
We are on the record calling file number 22192762. The file is entitled Calvary SPV versus Veronica Rome. We were last together on this file on January 24th, 2023. At that time, the parties and court agreed on today, February 21st, 2023 at 10 o'clock for our next pretrial. Plaintiff has failed to appear. Defendant has appeared. This matter is dismissed without prejudice. We'll send you out a notice today, ma'am. Thank you for coming in.
thank you so much, Judge Robertson.
Yes, ma'am. Be safe.
You too. Thank you.
storytelling at the end of this guy's pen. We just heard music like Dale, this water music with the new London construct by like people to pick it. Remember that anytime you got that craving for classical music, you're invited to visit cbc.ca/listen, where you will find over 200 listening experiences to choose from, including classical music playlists. Again, cbc.ca/listen, it's free. Now you're listening to Tempo here on CBC Music. I'm joining us on. We got more classical music from you right now.
Hello,
Hello, what is your name?
Malcolm Brown.
Malcolm Brown?
Yeah,
We are on the record. We are calling file number 22-193-135. Credit Acceptance Corporation versus Malcolm Brown. Could I have your appearances?
Good morning. Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
And what is your name, sir?
Malcolm Brown.
All right. This is the date and time set for by a notice dated January 24th, 2023. Plaintiff's motion for summary disposition. Mr. Brown, did you file an answer to that motion?
No,
Counsel, your motion. Thank you, Your Honor. We did file our motion under MCR 2.116 C9 and I1 as well, Your Honor. Defendant has not stated a valid defense. Plaintiff did attach the contract to its motion, and defendant does not deny that he does owe this debt. So we are asking for a motion to be granted at this time.
Well, counsel, since you submitted matters outside of the pleadings, the court will treat your motion as a motion under C10. Your unopposed motion for summary disposition will be granted. I look forward to your order granting summary disposition. Mr. Brown, you have an absolute right to appeal my decision. That appeal will be effective 21 days in Wayne County Circuit Court from the entry of that order, which Ms. Matt Francis will be sending. Thank you both for coming in. We're off the record.
Thank you, Your Honor.
He always. Hello. Good morning. Good morning.
What is your name?
My name is Laura McDuffie.
All right, we are on the record. This is file number 22-195-542. DNF Associates versus Laura McDuffie. Date and time for pretrial. We were last together on this file on January 24th, Appearances, please.
Good morning, Your Honor. Brian Bruin, GROEN, P number 56673 on behalf of plaintiff.
And your name again, ma'am?
My name is Laura McDuffie.
Okay, where are we in terms of our written discovery, people? Are we done?
Actually, I would keep it open, Your Honor. I don't think from my notes from the last hearing, it does not look like we sent her a copy of the statements that we have, which I think will be beneficial in this matter. So I am ready to get mailed out, and I will do so today. That way she can look the statements over, kind of glean where we're getting our numbers from, and we can kind of see where that takes us.
Ms. McDuffie, are you
Okay.
planning on doing any written discovery?
I'm just going over all the notes and I'm realizing this is the third collection agency that's trying to get money from an account where the original creditors violated the agreement twice.
Okay,
This
I'm
will
gonna
be the third collection agency.
I'm going to continue then your written discovery for another week. Another period, excuse me, not.
As I say, that's a little tight, Your Honor.
I didn't mean a week, I'm sorry.
No, that's okay.
We'll see you guys again, March 20th, at 11 o'clock. Your written discovery will remain open. Anything else?
Sounds
we
good,
can
Your
do
Honor.
today?
So one other thing, so you'll be mailing me all the documents you have and showing how you came up with that $1,047 figure?
Exactly. These are going to be copies of the Indigo credit card agreement or the credit card statements.
Because this shouldn't even be taking place because they violated two different
Ma'am?
agreements and you're the third company.
Well, if you have copies of those agreements, please send those to us and we can forward those to our client because we don't have any of that. We have no information about any agreement. So that's what we need from you.
Okay, let's stop right here. I'm going to put you guys into a chat room so you can have whatever conversations you need to have. And I'll see you again March 20th at 11 o'clock. Your written discovery remains open. Let me
Thank
get
you,
you
Your
out
Honor.
to the chat room.
Okay. Hello?
It'll be a second. It'll come up on your screen.
There it goes. Thank you, Your Honor.
All right. Thanks for coming in.